Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding the answers to our elder care and estate planning questions. I'm your host, Mary Ravasio. Joining me is Doreen Seamon of Seamon Law Offices. Doreen is licensed to practice law in West Virginia and Pennsylvania, where she focuses her practice exclusively in elder law and estate planning. Doreen is also an accredited attorney with the VA. Hello, Doreen, and welcome to Elder Care Answers.
Hi, Mary. It's great to be here today. Thank you for having me.
Doreen, when we get together, we talk about so many things such as estate planning, settling a person's affairs after they've passed away, protecting a person's assets in case of an illness, and even veterans' pension and compensation. I just assumed most people took care of these things, but I was so surprised when I recently read an article that said less than 1/2 of Americans actually have an estate plan.
Yes, so many people just don't have an estate plan, or if they do have one, it's outdated.
You and your team have over 20 years specifically in estate planning and elder law, and during that time, you've worked with hundreds of families. Based on your experience, why do so many people procrastinate when it comes to something as important as estate planning?
You know, so many people want to do what they need to, but there's a lot of confusing information out there, so sometimes they just don't know where to start.
I agree. People often tell me that they don't know where to start, and it's confusing.
Let me tell you about a client. We'll call her Sue. Sue was diagnosed with Alzheimer's, and she was still doing fine, but she knew she should start to get some things in order. Sadly, Sue was familiar with Alzheimer's dementia because her mother had passed away from Alzheimer's as well, and Sue had been her mother's primary caregiver.
That's really sad, but since she went through it with her mom, it sounds like she would know what needed to be done.
Yes and no. Like you just said, Mary, it gets complicated. So Sue needed some guidance so that she could take care of some things in advance.
So in addition to the Alzheimer's dementia, what made Sue's situation more complicated?
It goes back to the decisions her mother made without the advice of an attorney who works exclusively in elder law. You see, years ago, a neighbor told Sue's mom that if she became very ill and needed nursing home care, that she'd lose her family farm. So of course, her mom didn't want that to happen. So she worked with an attorney to give Sue the family farm to get it out of her name in case she needed long-term care. Now the farm had been in the family for decades and had appreciated in value quite a bit. Her mom also put Sue on her accounts as co-owner so that Sue could easily access them to pay the bills as her mom's disease progressed. Sue's mom figured that it would be really easy for Sue to distribute the farm and money to her siblings after the mom died.
Oh no, I've talked to you enough times to know that might not have been the best solution.
Yes, you're correct. So, shortly after mom died, Sue quickly worked with an attorney to honor her mom's wishes for her to distribute the farm and money to her siblings equally. Finally, Sue had time to focus on herself and found out that she was in the beginning stages of Alzheimer's dementia. That's when Sue contacted our office to help her get their affairs in order.
That's good, but were you able to help her?
Yes, but it was much more complicated than just doing Sue's estate plan because legally, mom's assets were Sue's when mom died, and that means Sue gifted them to her siblings. It wasn't an inheritance from their mother.
What effect did that have on Sue's estate and her siblings?
Well, as I mentioned, the farm had been in the family for a long time. And since mom gave Sue the farm while mom was still alive, they lost a great opportunity to avoid capital gains taxes. Meaning that if they sold the farm now, they might have to pay federal and state taxes that could be over 30%.
Could you have helped them avoid that and get the farm out of mom's name?
Yes, that's something we do pretty regularly for our clients. But even if mom had gifted the farm outright to all of the kids, it wouldn't have helped the capital gains tax issue. Now, there's another issue regarding Sue gifting the farm and other assets.
More issues, not just the tax issue?
Unfortunately, yes. The thing is, although Sue's doctors were hopeful they could delay the progression of her disease, they couldn't guarantee how long it would take for her Alzheimer's dementia to progress before she might need 24/7 care like her mother did. Sue's son, Joe, lived nearby, and he thought he might be able to help her through that stage, but he needed to work as well, so they could not completely rule out a potential stay in a nursing home.
So now she gave away assets and might need care within the 5-year look back?
Exactly. Now, for our viewers who aren't familiar with what the 5-year look back is, it means that if a person enters the nursing home and runs out of money and tries to apply for long-term care Medicaid, they may be ineligible for a period of time due to gifts they made within the prior 5 years, the 5-year look back.
So how did you help Sue? She already made the gifts.
Fortunately, Sue has a great family, so we had a family meeting to explain what was going on. The family agreed to return the assets to Sue as long as Sue moved the assets to a trust to protect the assets for the extended family.
How does that help? Isn't the trust a gift as well?
Yes, it is, but the trust makes it easier to carefully protect and manage the assets so that if Sue needed long-term care before the 5 years passed, that we could easily adjust the plan as needed.
It sounds like Sue and her siblings are a very close-knit family, that they would even consider this option. But I imagine it doesn't always work out that way.
You're absolutely correct. We were lucky that they were all willing to work together. So basically, we safeguarded the assets in the trust so that we could get the best overall outcome tax-wise and Medicaid-wise. It was very important to all of them that the family farm would be protected as much as possible.
So I'm curious now, what happened to Sue? Did she end up needing long-term care?
Actually, she did, but because of the trust and the planning we did, the farm and most of the money was protected, although it wasn't as easy as her mom had hoped.
Let's go back to Sue's mom. She was trying to be prepared and make the best decisions, but I guess she didn't get good advice. If you had worked with her, how could things have been different?
That's a great question, Mary. I was really happy to help Sue accomplish her mom's goals and get things prepared for her journey. But I wish that I had met them years before because I could have made things so much easier for all of them.
Easier how? I mean, obviously Alzheimer's, dementia, or any long-term care issue is a terrible thing to go through.
Yes, it is, and I can't help with that, but I can help make the other issues in a person's life easier so that if and when that happens, it will be easier. For example, had I worked with Sue's mom, I would have made sure that she knew what options were available to protect things like homes, farms, cash, and other investments.
And then she would have done a trust then?
Maybe. Now for her, I do think a trust would have been the best solution, but it wasn't my farm or money to make that decision. She deserved to know the pros and cons of all of her options, then she could have made the best decision for her.
I think that's what people are looking for, just an honest conversation about their options, and then they can take that information and make the best decision for them and their family. Knowledge is power.
Yes, now some of this can be a little complicated, so that can be intimidating for some people. So I like to simplify it as much as possible.
Do you think that's why some of us procrastinate? It's a subject that is unsettling, and we know that it can be complicated.
Absolutely, but it's a lot less unsettling to plan ahead while you're healthy, and we're discussing what you would do and what you would want to happen if, say, you fell and bumped your head, as opposed to you had just been diagnosed with a serious life-threatening illness.
That is so true.
And in regard to complicated, it isn't rocket science. It's just a new concept to most people. Given the opportunity, I can explain it in pretty basic language, and of course, the client can ask their questions to get a good understanding.
So that makes sense. Explain the options, whether it just be a deed or a trust or whatever. But learning your options and making a decision while you're healthy has to be easier than dealing with it in a crisis. So now, after hearing the story about Sue and her family, we understand the importance of having a comprehensive estate plan with the guidance of an estate planning attorney who also focuses on elder law. But where does it all start? When we return, Doreen will explain when a person should get their estate plan in order and an important document every adult should have when Elder Care Answers returns. Welcome back to Elder Care Answers, the show that explains how to prepare for your elder care and estate planning journey. Doreen, we know how devastating it can be to have inaccurate advice regarding estate planning when we're facing a crisis. So I want to discuss how can we be prepared no matter what comes down the path.
Yes, I agree. I want our viewers to understand that while we need a good last will and testament to take care of our affairs after we pass away, there's also documents we need to have in case we have a period of incapacity during our lifetime as well.
So really, to protect your clients, those documents that prepare for the unexpected while they are living is probably the most important part of what you do for them.
Absolutely. Every single week we get several telephone calls on this issue.
I can't imagine my loved one no longer being able to make decisions and our family frantically trying to figure out how to do right by them during that crisis.
I'll tell you about a client we'll refer to as Jim, but to be honest, the names and some of the facts may vary, but this scenario is very common. Jim was the head of the family. He was an engineer and well respected in his field, and he appeared to be pretty healthy when he had a stroke in his 50s. Jim went from a functioning independent adult to being incapacitated.
Oh my, that is just so scary. What type of help did his family need?
It was a mess. Jim was going to need extensive therapy, but the general consensus was that he would never be able to return to the family home because it wasn't handicap accessible and it would be difficult to make it accessible.
Sounds like Jim might need a new home.
Yes, but Jim was mentally incapacitated, so he couldn't give legal consent for anything. Jim's name was on the home as well as the other assets he and his wife Sarah owned, meaning Sarah couldn't sell the home without Jim's consent. And her other concern was that, like most people their age, the majority of their savings was in his IRA, so she was worried about how to access it to pay for their expenses. Her hands were tied.
But she would be selling the home or using the IRA funds to help him. It was probably for Jim's benefit as much as hers. Did she have a durable power of attorney?
Now, for our viewers who might not be familiar with what a durable power of attorney is, it's a document that appoints another to act on your behalf for non-medical decisions in case you can't take care of your affairs yourself, just like the situation Jim found himself in. In contrast, a medical power of attorney is used for your medical decisions. They're usually two separate documents. But for our viewers, the medical power of attorney you complete at the hospital or your doctor's office does not address your non-medical decisions. And yes, Mary, Jim actually did have a durable power of attorney.
Great. So that is how his wife can sell the house and do what is best for both of them.
Well, I wish that's how it worked out. But you see, when they completed their powers of attorney, they didn't agree to the elder law and disability provisions because they didn't understand why they'd need them.
So giving the agent under a power of attorney the power to sell your home is considered an elder law and disability provision?
Well, the provision that was missing here was a self-dealing provision.
Self-dealing. That doesn't sound like a power I'd want to give to anybody.
I understand your concern, but Jim's agent under his power of attorney was his wife, and the backup to his wife was his son. So obviously, both of them are potential heirs to Jim's estate. The way the law looks at it, anything they do on behalf of Jim and saving Jim money could benefit his wife and son as well, since they're his heirs. That's why it's considered self-dealing. So we recommend that the document provide for self-dealing, but then make sure that the agent can only self-deal if they're using that power for good, not evil, which is called a fiduciary duty.
That makes sense. It sounds like something we wouldn't want, but if there was an incapacity, especially a longer one, we might need it to protect our interests and those we love. Are there other elder law and disability provisions we should permit in our power of attorney that people are often unaware of?
Yes. Let's imagine that instead of Jim having a stroke, that he and his wife were in a car accident. Now, Jim was going to die, but his wife was going to need expensive long-term care the rest of her life.
Now, I know long-term care in a skilled nursing home in our viewing area is usually over $10,000 per month, and sometimes much more than that. So I'm sure we'd want to figure out a way to protect some of the money.
If I was working with the agents for Jim and Sarah, I'd suggest that they divert as much of Jim's estate as possible to a trust for the benefit of Sarah, rather than directly in her name.
So then Sarah can qualify for Medicaid sooner.
Yes, it's easier to protect some of Jim's estate before he dies and Sarah inherits it. Then we have some assets protected to provide whatever Sarah needs above and beyond what Medicaid provides.
How would the agent do that?
The agent could make a trust the beneficiary of Jim's IRA and life insurance. They may be able to retitle some assets as well.
I'm just confused as to why they didn't tell their attorney to put that into their documents.
It's important for us as the attorneys to explain these options to our clients. Most of my clients would not know to ask for it. It's a point we have to explain to them. We know to discuss this because we work with people who are dealing with these types of issues on a regular basis.
If I think back to my grandparents' generation and before, most people didn't need to think about these elder law issues because they didn't live for years or even months with these long-term issues.
Exactly.
Doreen, what about veterans? I understand they need to have good powers of attorney as well, but do they have any special considerations?
Yes, but it depends on some factors. So first, let's discuss veterans who were injured due to service, or maybe they had a health issue that they didn't even know about, but due to their service, the condition became apparent. In either of those types of cases, we're talking about disability compensation. So the veteran didn't have to serve during a war.
But there needs to be a connection between their service and the health issue related to the disability?
Yes, it's basically compensation for the injury. Veterans don't need an attorney to apply for disability compensation, but if they believe they were wrongly denied compensation, then they might want assistance in obtaining it.
Can you give us an example?
Yeah, the more obvious would be a veteran who has PTSD or has lost a limb, but it could be more subtle, such as suffering the side effects of Agent Orange exposure, which can also be devastating.
Now, what if they weren't disabled due to their service? Is there still some help available to them as they age?
Yes, for those veterans and their surviving spouses, they might want to consider applying for the improved pension or even the aid and attendance level of the improved pension.
So how does that work?
For this pension, they need to have served during wartime and then either be at least 65 years old, or if they're younger than 65, then they need a VA disability rating. If those requirements are met, then we can analyze the medical expenses, prior gifts, assets, and income.
This one sounds complicated.
Well, it can be more complicated in some ways, but it opens the doors to a monthly income that's to reimburse you for your medical expenses. Depending on which spouse is applying or if both are living, we could be looking at about $1,300 to $2,200 per month reimbursement.
So if a wartime veteran is spending money on medical expenses that aren't being reimbursed, they could potentially get over $2,200 per month to reimburse them for those expenses?
Yes. It isn't just free money, though. It's related to reimbursing qualifying veterans or their surviving spouses for medical expenses that aren't covered by insurance. I have some clients who have been on this pension for over 8 years, meaning they've received almost $100,000.
Wow, that could be life-changing for a veteran trying to pay for a caregiver at home.
I know it sounds a little complicated, but if a viewer wants us to screen their case to see if they might qualify now or in the future, we're happy to do this as long as they're willing to provide some basic information that we'd need for our analysis.
So how do you know this information?
I'm a VA accredited attorney. It's a special training I've done to become and remain accredited. I'm required to do certain continuing education on VA benefits on a regular basis.
Now, I know you're licensed in both West Virginia and Pennsylvania, but how does that work in the VA? Can you still only help clients in those two states?
Actually, I can help any of our United States veterans with their VA pension or disability compensation, regardless of where they're located. But if they also needed estate planning assistance, I can only work with those in West Virginia and Pennsylvania.
Well, now we understand more about veterans' benefits and the importance of elder law and disability provisions in durable power of attorney documents. When Elder Care Answers returns, Doreen will explain how to navigate the probate process. Stay with us. Welcome back to Elder Care Answers. We've been talking with elder law and estate planning attorney Doreen Seamon regarding very important provisions of an estate plan. Doreen, I know you work with trusts a lot, so let's discuss who needs a trust.
Whether a client needs a trust depends on what their goals are. There are a variety of types of trusts with a variety of purposes. They're usually created to gain some advantage, such as protecting assets from the high cost of long-term care, mitigating taxes, or controlling how and when a beneficiary receives a gift or an inheritance.
So where do we start?
Let's just break them down a bit for our viewers, and then we can do another show to describe them in more detail.
That sounds like a good idea. Let's start with controlling how and when a beneficiary receives a gift or inheritance.
Perfect. Okay, so let's discuss a client we'll refer to as Bill and how a trust helped him. Bill had 3 kids that each had a different situation that pointed him to giving them their inheritance in trust.
Okay, tell us about Bill.
His oldest daughter was in a bad marriage. Her husband was bad with money. Bill thought she'd do okay with the inheritance, but he wasn't sure about that. In his estate plan, we were able to direct her inheritance into a trust that would be used for her benefit, kept out of her potential divorce, and would keep her from foolishly spending it. And if she happened to have money in it when she died, Bill could direct that trust to benefit other family members or charities.
The perfect solution for her.
Then his second daughter was just a little young. She was 17 years old, so even though she was almost an adult, he had no idea of how she would handle money or who she'd end up marrying. So he wanted her to have her share in trust to be used for education, getting a good start in life. And then he figured when she was 25 years old, he wanted her to have the right to the entire trust.
Now, to me, 25 might still be young, but it's Bill's money. How about the third child?
Well, this child was only 10 years old, so she would have needed a trust like her older sisters did, since you don't want to give a minor money in their name. But the more pressing issue was that she had Down syndrome, meaning she was eligible to receive means-tested public benefits, so she shouldn't have assets in her name that could affect those public benefits.
Could Bill just give that money to somebody to hold for that child?
Technically, yes, but that's not a wise way to do that. The person holding the money could lose it to financial issues, divorce, their own health issues, or they could pass away and not have addressed that money in their estate plan, meaning default state laws would likely direct that the money went to his spouse or children. Public benefits can be so complicated. A supplemental needs trust was the perfect type of trust for her.
So who manages the trust?
It's whoever Bill picks. He's divorced, but he's on good terms with his ex-wife, so he actually chose her to watch over the trust. She won't ever inherit from him or the trust, but she can invest it properly and then distribute it per Bill's wishes for the daughters.
What if Bill wanted to give money to the girls while he was living, maybe for education or to buy their first home?
He may be able to just gift it as he goes along, but sometimes parents or grandparents will create a special kind of trust that can be used for those things and then gift to it during their lifetimes rather than upon their death, especially if they're worried that their estate may be so large that they might have to pay estate taxes when they die.
That makes sense. But what about the trust your clients use to protect assets from the high cost of care in a nursing home?
That's a special type of irrevocable trust. The nickname for it in our office is called the box because our clients like to visualize that they're safeguarding assets such as a farm, their home, or investments in a safe place such as a lockbox.
So the box is the trust that's best to do 5 years in advance of needing long-term care?
Yes, that is the best outcome. But if a client doesn't make it the 5 years, the box is still typically useful. It's just that we didn't get the best advantage like we'd hoped. For our veterans that are trying to get the improved pension, the look back for that's only 3 years. So many of them use the box to start the 3-year look back for the VA pension, but then it also starts the 5-year look back for a long-term care Medicaid.
And having the shorter look back for the VA pension sounds great, especially since the trustee can still access the assets if the situation changes.
Right. The person creating the trust doesn't have direct control over their box, but they usually choose somebody they trust to manage their box, so indirectly there's still some control.
Now, Doreen, what's the best way to reach you?
Either by calling our office or going to our website to our client contact form. If you prefer to call, that's great. Some people call at all kinds of crazy times of the night, which is fine. We can just call back the next day when we get back to the office.
So I guess since it is an office, they don't have to worry about waking anybody up. Now, what about the website? How does that work?
It's simple. Just hit the Contact Us button on the top corner. Or if you aren't sure that our team is the best fit for your specific concerns, you can hit the Schedule an Appointment button to schedule a phone conversation with our intake specialist to figure that out.
So once I have an appointment, how long does it take to get my documents?
Usually after you engage to work with us, it takes 4 to 6 weeks for us to finalize everything. That usually involves 2 meetings. The first meeting may be in person, by telephone, or even virtually, but usually the second meeting's at our office for you to sign your documents in front of our notary and witnesses.
That sounds easy.
Funny you say that, Mary, because that's exactly what people often tell us after the work is completed, that it was so much easier and less stressful than they anticipated.
Doreen, you've certainly given us a lot of really helpful information today. Thank you for walking us through this sometimes complicated process.
You're welcome.
So now you can get help building the foundation of your estate plan by contacting Doreen's office, 304-554-2900. You can also visit their website, SeamonLawOffices.com, to request an appointment, watch more of our television shows, or find other resources to help with your estate plan. Be sure to listen to their podcasts and follow Seamon Law on Facebook, LinkedIn, and Instagram. Thank you for joining us today, and we'll see you next time on Elder Care Answers.